All right, welcome everyone. We are back here with Mending the Sacred Hoop TA's Key Issues and Promising Practices webinar series. Super excited to have you all with us today. My name is Jill Belfi. I am the Learning and Resource Coordinator with Mending the Sacred Hoop TA and Mending the Sacred Hoop Coalition. Today we have Kelly Gaines Stoner from the Tribal Law and Policy Institute here to share information with us on sexual assault protection orders. Kelly is a wonderful presenter, as I mentioned a little earlier to those that jumped on early. Her energy is profound, so much so that it translates virtually, which is a big deal these days. So I'm excited for you all to learn alongside me with Kelly Gaines Stoner. So if you haven't already, grab yourself something to drink or grab a last minute bathroom break. And we're going to get started here shortly with Kelly. A couple things before we do jump into Kelly's presentation. August 3rd is our next webinar as a part of our series, and that's with Jessie Midland from the Victim Rights Law Center. And she's going to talk to us about privacy, confidentiality, and privilege, what every VAWA funded entity needs to know. And if you haven't already signed up for this particular webinar series, there will be information coming out via email soon. And you can also always go to the OVW Tribal Events tab on Mending the Sacred Hoops website and register that way as well. We look forward to having you join us. We have put quite the lineup together, and it's really been a wonderful series so far, and I know it will promise to continue to be. A couple of housekeeping items before we jump in. So this is Zoom webinar. So as such, your video is disabled, as is your audio right now. So if you want to chat amongst panelists, which would be Kelly, myself, and Holly Oden, you can certainly do that. If you want to ask a direct question of Kelly, use the Q&A function. That's going to be the best way to make sure that she gets it, because we will know right away, like, this is specifically a question for Kelly. Also, if you really want, I strongly encourage you to use the raise hand function, and you can speak your question audibly, and we can just unmute you for the time being. Unfortunately, the video is disabled, but the audio is something that we can allow. If you do have any technical issues, please type in the chat to Holly Oden. She is standing by to help with those sorts of issues. You can also email her, and her email is there. If for some reason you get kicked out, if you know that that's an issue of yours, you can jot down her email address, and she will be standing by again to help with anything she can in the best of her ability in terms of technical issues. So with that, I'm going to bring Kelly on screen here. And Kelly, I didn't ask you, but are you willing to do another little icebreaker today? It's going to be different than the last time. How are you feeling? Sweet.
Sure, I would.
Sweet. Yeah. I'm going to bring up your PowerPoint. And as I do, I'm going to ask you, Kelly, today, where you're at, what kind of animal do you feel like today?
Oh, gosh. I thought that was what you were going to ask the last time. So I had something wonderful.
Keeping you on your toes.
I think, yes. You know, I'm going to say a dragonfish.
Wow.
Just because I went to the aquarium in Atlanta last week and I didn't know there was a dragonfish, and it sort of looks like a seahorse, but it has some dragon stuff going on, and I thought it was really cool. I don't think
so. That's more like what you want to be. That's kind of what you want to be, right? Not necessarily what you feel like. Yeah. Well, okay.
Well, I might be, and I think if what I feel like I am today. Kind of tired and slow, so I'm going to say a turtle.
Ooh, I like it.
Like a turtle.
Slow I like
motion, but still steady and centered. Yeah.
Beautiful.
Don't forget about the dragonfish. Don't forget about y'all. Google that. That is a cool animal.
I am definitely going to. I'm very interested now. I'll look that up. All right, Kelly. I'm super excited to learn alongside everybody else today. So welcome.
Thank you. Thank you. And thank you to all the listeners out there. And thank you to all the advocates out there who are working to keep victims safe and making sure those victims have the services they need and a voice in the whole system. So let's get started. And I know Jill went through some of the housekeeping tools. And so I just want to make sure that you have access to all the information that you need. And if you have questions as we go along, I don't want you to wait until the end. I want you to just put it in the Q&A, the chat, or raise your hand, and we'll get right to those. So today we're focusing on tribal sexual assault protection orders. You're going to find as we move through this presentation that there is quite a bit of overlap between a sexual assault protection order, and again, we're sort of focusing on these orders being issued by the tribal court, although we can go outside of that if you have questions. There's quite an overlap between the sexual assault protection order and the domestic violence protection order, just in its structure and what we would want to see in the order, but there are some distinct differences, and we're going to go over those today. And for those advocates in the listening audience that might have questions as we move through this, or a comment, something you think should be added in that I didn't say, again, please use the Q&A, the chat, or raise your hand. So with that said, I'm so thankful that Jill is agreed to move my PowerPoint. I'm in rural Oklahoma. I can't have video, Zoom, and move the slides. My computer the internet won't support it. So we're just saving everybody some frustration, and Jill's doing that for me. And I also want to just give a shout out to Mending the Sacred Hoop, the whole crew, Holly and company, just have been so supportive and reminding me and keeping me focused, and they've been so kind and gracious, and I'm thankful for the invitation. So we can move to the next slide. Jill will get the show on the road. Okay, you already know who I am. Just a little bit more though. I do want you to understand the lens that I'm speaking through. So I think it's based upon my experience both as a lawyer, working with Native victims, all but 2 years of my 20+ year practice history, 8 years as a tribal judge for a tribe here in Oklahoma, 20-something years of teaching law school courses on domestic violence in the lawyer, civil and criminal jurisdiction in Indian country, just a whole host of topics like that. But I think I get most of my grounding with respect to victims and their needs, and the importance of working side by side with an advocate as the case progresses through whether it's the civil system or the criminal justice system, is just working with advocates and the importance of that and what advocates bring to the table, and how when the attorneys pair up with an advocate, it empowers the victim, and I think the results turn out so much better for the victim. So I've got years and years of experience of that, and from time to time I hear the advocates that I've worked with in the past commenting, Kelly, that's going to be, we're going to have to safety plan. That's changing the dynamics. Things are about to get more dangerous now. So I try to incorporate all of that, although I am not an advocate, no way near an advocate, but I've learned such a great deal from the advocates and the coalitions. So let's go to the next slide so you can kind of see where I'm coming from. Seen cases on both sides of the bench as a lawyer and as a tribal judge. So what I hope that you're going to get out of this, and what we are going to focus on in this particular presentation today, is we're going to be using words like burden of proof. How much evidence, how persuasive does that need to be to the fact finder, the judge? We're going to talk about possible remedies and how those remedies in the protection order itself might be a little different for the sexual assault victim, especially the sexual assault victim who has been assaulted by a non-intimate partner. They didn't have a relationship with this person. We're going to go through the parts of the protection order, and this is such an important piece because it does us no good to get a protection order if the protection order isn't enforceable. But what I mean by that is if there's a violation of the protection order, you can't even really tell. As a lawyer, I'll say, I can't, that's written so broadly, there's no way I could prosecute that violation. We're going to be talking about getting down into the weeds a bit about the parts of the protection order, and they're crucial to enforcement of the protection order. We will also talk about full faith and credit, VAWA's full faith and credit mandate. And I'm most interested in that particular topic as it applies to enforcement of that tribal protection order outside of the Indian country that issued it, outside of the sovereign that issued that. So we're going to talk about that. And if you have questions or comments when we get to that part, I'd love to hear it. Although I'd love to hear them all the way throughout. So next slide, that's what we're going to focus on today. That sets the stage for us. We can kind of get our minds right with that. And let's start with the differences, some basic differences between the sexual assault protection order and the domestic violence protection order. And you can see what the slide says there. With the sexual assault protection order, it may include that stranger that committed acts of sexual assault or sexual violence against the victim. Whereas, generally speaking, domestic violence protection orders may require some sort of relationship be established. Now, how would I know this? Well, you will look to your tribal statutes, and they're going to tell you what has to be proven in order for the tribal court to issue a protection order. You're going to find lots of good information in the tribal statutes too, such as who can ask for a protection order. How do they ask? Do they have to be an adult, a child? What kind of relationship has to be proven to the court? And and here's another thing, you may not find in some tribal statutes, there may only be one kind of protection order. And again, these can be called a whole host of different things. Personal protection order, family violence protection order, just a whole host of things. You may only find one kind of protection order. And I think that's going to be important for you all to really look at those statutes and figure out, do we have a sexual assault protection order, or does that roll over to the domestic violence protection order? And if it rolls over to the domestic violence, do we have to demonstrate that relationship? Because that may totally knock you out of even bringing in a victim of the crime of sexual assault and trying to get a protection order if that relationship is required. So again, something for you all to go back, look at the tribal statutes and the tribal courts that you're practicing in, and get this information. And as I was preparing this morning, drinking various cups of coffee, I wanted to ask you all a question. This is sort of unscripted, so I'm just curious. As I was going through this, I was thinking of all the clients that I've taken in to get protection orders. I don't know that I ever asked whether they wanted a sexual assault protection order or a domestic violence protection order. I don't know that that's a part of my questions to the victim. I think I rely on the advocates to tell me. But I would like to get your perspective out there in the audience. Do you feel that there is a stigma or a hesitancy, perhaps, on behalf of the victim if the label of the order says sexual assault protection order, as opposed to just protection order or domestic violence protection order? Anyone have any comments on that? Do you see a victim perhaps being hesitant to share that with the public, that a sexual assault has occurred and they feel they need a protection order? Just thinking about the title of the order itself. Do we have anybody in the chat that wants to? Okay. I hear, okay, I'm seeing some good responses here. The PO needs needs specific information, yes. And we talked about going back and look at the tribal statutes. Tribes are going to be across the board on what's required. And also taking note that the perpetrator, very important point, Renee, thank you. The perpetrator is going to read everything in that affidavit or the application for the protection order. So I think that's, I just think, I wondered to myself today, and I've been doing this for years and years and years, wow, should I be asking victims if I can get a domestic violence protection order and the tribe doesn't require me to show a relationship with the evidence? Should I be asking which of those orders they would prefer? And also, as I was reading, doing the research, kind of just refreshing my memory for this today, I can see, at least in state courts, some states will require you to go after the domestic violence protection order if the sexual assault was an intimate partner, someone the victim had a child in common with, family member, lived together with, those sorts of things. So I think I was just wondering if the label of the order re-victimizes the victim in some way, and if so, what sorts of things would advocates do? And I'm seeing yes. Heidi Beth Burns is saying yes. It labels, it re-victimizes. Yeah. So again, Renee, thank you. Renee, I think I know you. Judges need specific information. Yes, and we're going to talk about that later. We're going to talk about the findings and how important they might be to the victim and other areas of the victim's life. But again, just something I thought, if you could all just take some time to ponder on that and see if there's a place, if you have room in your practice as you serve victims, to decide which way the victim needs to go here to prevent victimization. And again, I think one of the participants already pointed out, the affidavit, or the application, whatever form that victim is filling out to request a protection order in the first place, a civil protection order we're talking about now, the defendant's going to get a copy of that, or the perpetrator, and they're going to get to read it. And in most instances, it's public information. So at this stage, I just want to give you a nugget here, that when we're thinking about, well, what is this going to cause, what kind of protection order and what kinds of evidence do we need to really bring forward? Let's be thinking at the outset here about using any available tribal statutes to protect information from public view. And that may, some of that may be redacted and it can be talked about in court, but is not necessarily available to the public. And there's a variety of statutes that will protect victim information, all different types of victim information as the case progresses. So, but you only will probably get those protections if you have tribal statutes that are on point, that say a victim has a right to protect information and the judge can redact part of it, can get that out of public view. All right, next slide. The burdens of proof, I told you we were going to talk about this in the objectives, and you'll see here right off the bat, the burdens of proof are exactly the same. Usually, I have to talk generally because tribes have sovereignty to make decisions and change these burdens of proof. But right now we're talking about civil, and it's a preponderance of the evidence, and that is 51%. I always like to think if you had 2 glasses of water and they're both half full, add 1 drop to just one of those glasses, and that's a preponderance. Ever so slightly, 51% tilt. It's not a very high burden of proof in the law, but I want to say a word about that. Burdens of proof, as an advocate, you might be looking, you say, well, I've got all this evidence. We're going to be able to, that's easy for us to reach that preponderance. But the preponderance of the evidence is through the eyes of the judge, what the judge finds believable. We're going to have 2 sides to the story, and the judge will hear from both sides. Both sides are going to be given facts of probably what has occurred in the assault, and the judge is going to probably assess credibility slightly one way as opposed to the other. And that is when you win the case. When the judge has made the decision, 51% goes to either the victim or the perpetrator. So the burdens of proof are the same, and the types of evidence or considerations for the sexual assault victim still very much the same as you're going to find in the domestic violence case. And one thing I want to say here too, some of you may be wondering, well, what is sexual assault? I mean, what do you have to prove? And the way you find that out is to look at those tribal statutes. It can be sexual assault, it can be sexual abuse, it can be termed many, many different crimes, but you will find the types of touching or penetration that is required to indeed demonstrate a sexual assault. Now, we're not talking about the criminal beyond a reasonable doubt, which is the highest in all of the law. We're talking about civil, and that's much easier to demonstrate by a preponderance. So just to give you some ideas, generally speaking, we might see sexual assaults, sexual abuse, sexual violence requiring some sort of penetration of the sex organs. We might see other statutes that do not require that could be touching outside the clothing. So it's going to span the gamut here. Again, hopefully underscoring the importance of you going back to your tribal statutes, getting that statute out, highlighting it, so that will inform your interview with the victim, so that you're gathering the relevant information. And we just listed a few here, and they're the same for both, except we're not necessarily, if it's a stranger sexual assault, not necessarily thinking about the domestic violence power and control wheel, and many of you are familiar with. So we would think about photos, videos, phone messages, and text. That is just sometimes a fertile ground for getting messages, sometimes from the sexual assault perpetrator, even if it was they hooked up in the evening, then the sexual assault progressed. That person texting the victim saying, "So sorry, things got out of hand. Are you feeling okay? It seems like it might be weird." Now, these are the less egregious, less violent sexual assaults, perhaps. But again, always thinking about this. Well, did you get any phone messages? Have there been any texts? Were there any cameras around? Were there any witnesses? Are there signs of a struggle? There don't have to be. No should be enough. But were there signs? Anything you can do to bolster the victim's testimony? Medical documentation, if any sort of ER visit or SANE exam was done, what was told to law enforcement, all of those things become very, very relevant and very important as you take the client in and begin the sexual assault protection order process. Next slide. All right, now let's get down. If you have any questions, because I'm moving kind of quickly, we're going to go back over the pieces of the protection order and their purpose after these first few slides. But I want you to focus again on the possible differences between sexual assault protection order and domestic violence protection order. These are just some general examples. There are so many more. And I always like to give my spiel here. I do, and I sat on the bench for 8 years. I know the dockets get super crowded. I know the clerks are super interested in having, not having the docket last longer than the workday. But I will tell you, I think as a former tribal judge, I think utilizing forms to draft remedies in a protection order, I think I'm on the fence about that. And I think I think I'm okay with some remedies being a check the box, but I also think there needs to be another category in your protection order that says other remedies. And I really feel like the remedies, it's a critical piece of the protection order. It's the tripwire for the defendant. It's the command of the court outlining acceptable behaviors, commanding that perpetrator to comply with whatever the judge feels are acceptable behaviors, and protective maneuvers, stay so far away, 50 feet away, 50 yards away, no contact by third parties or text or any other electronic means. These remedies are super important. I get really nervous when I see tribal judges just check, sign, because not every victim needs exactly the same set of remedies. How do you know what kind of remedies the tribal judge might issue? Again, I'm just asking you to go back and look at your tribal statutes. Some tribal statutes will provide a laundry list of remedies that a judge can use as tools, remedies in the domestic violence or the sexual assault case or the protection order case in general. And if that's all that's listed there and there's no provision that says that any other remedy the judge feels will protect the victim and bring about the conclusion or the end of the violence, if that's not in there, as a tribal judge, I am bound to only utilize the remedies listed. Isn't that scary? So go take a look at that. Some of the remedies you might see in a protection order: no contact directly or indirectly or by a third party on behalf of the perpetrator, restricting access to the victim's home or restraining proximity to the victim's home, place of work, or place of school. Now these remedies that I have listed here are very general. These should not be copied and pasted into protection order because they're written so generally that a prosecutor really can't prove these violations beyond a reasonable doubt. We really need to get down to the nitty-gritty when we're drafting and say something like the defendant, and that's the perpetrator, I'm just interchanging those terms, the defendant shall not be within 50 feet of the victim's home. I need something specific in there because when I put my prosecutor hat on, I'm going to have to demonstrate that's been violated beyond a reasonable doubt. Also, protection from intimidation by a perpetrator. We're thinking about the perpetrator's family, those third parties. We're thinking about social media and everything that goes with that, Facebook, all of that. The judge can, if the statute allows, the judge can command that there be no mention of the victim or any of the events on social media. All right, next slide. Again, we're going to see a lot of crossover in the remedies between the DV cases and the sexual assault cases, but I just want to underscore, and I want you all to feel empowered once you've reviewed those tribal statutes to design those remedies to meet the needs of the sexual assault victim. I think a lot of victims worry about whether when when they ask for this, they get this started with their application or their petition for protection order, and they fill out their affidavit about what happened during the sexual assault or how they felt the sexual assault occurred. They wonder, if I get this started, what is going to happen to me on cross-examination, or what is, if the defendant doesn't have an attorney, what are they allowed to ask me? Are they allowed to ask me about my past sexual history to try and make it look like I have many partners? Or are they going to be able to ask me about my boyfriend, or what, those sorts of things? And it's hard for me to answer the question. We're talking about tribal protection orders here. So again, I'm gonna ask you, go back and check your tribal statutes, you may find, they're called rape shield laws in general. You may find these in the criminal section, and you could bring those over and say, Your Honor, this clearly in the criminal cases, this is not allowed. So we'd ask that you protect the victim during this testimony here today. So the only way that this past sexual history is going to come in, again, I'm speaking generally because your tribal laws are really going to be specific about this. If the past sexual history affects the believability or the credibility in the current case. So if there have been previous allegations and they've been dropped, and allegations and they've been dropped, that might, depending on how the tribal statutes are written, be able to come in for the purpose of whether or not the victim is believable. And again, only if the past sexual history relates to an important factual element of the case, your past sexual contacts with this abuser, specific instances of sexual conduct, that resulted in pregnancy, disease, the presence of semen, or past false allegations. And again, the attorney for the victim can file motions and upfront and try and get these issues decided, so that sort of puts the victim's mind at ease, or at least at a minimum be ready to argue these things in the tribal court during the civil protection order hearing. And we're talking civil too. Okay, next slide. So let's leave just the differences, some of the basic differences between sexual assault protection orders and domestic violence protection orders, and just the civil process in general around that. And let's go ahead and move into VAWA, full faith and credit. And it's found at 18 USC 2266 and 2265. I'm going to be going through those here briefly. And let me just start by saying why full faith and credit is super important to victims. Because when victims experience the trauma of going into a courtroom and having to share this very personal, sometimes violent encounters with the court, they, in my mind, when that judge listens and issues that order, that sexual assault protection order, the victim needs to be able to think in their mind, this is a command of a sovereign tribal court. This order, I can cross outside of Indian country and go to Walmart in the town. I can travel to another tribe. I can travel all around. And if the need arises, when I talk to law enforcement or others about my protection order, the protection order is not questioned. It will be enforced. I've already gone through this. A judge has already heard this and written down these commands. I shouldn't have to worry about it. And I wish that were the case, but it's not the case in some areas in the United States. So I want to set us up, as we're thinking about protection orders, I want to set us up to think about what has to be in the protection order in order to trigger this federal law that mandates states and tribes and U.S. territories protection orders that contain certain information will be enforced without question as they are written. That's what this is all about, this full faith and credit. It's supposed to be peace of mind to that victim as they're traveling around, that they're going to be okay, that order will be enforced. If they call upon law enforcement or others, they're going to have that. So to get this process started.
Sorry
yes.
for interrupting you. I think Shannon has a question. Is this an opportune time for her to ask that?
Yes. Okay, how does that work? Jill, does she just speak up? Do you unmute her?
Okay, sorry.
Shannon, are you out there? Are you unmuted?
Difficulties.
Oh, she's having difficulty, it says, Jill.
I forgot to put that.
Okay, Shannon, if you want to put that in the chat, if you're having difficulties, sometimes internets are fickle things. And as I said earlier, I can't advance my own slides from where I'm at here. So if you, yeah, we can hear you a little bit. Oh, I see. She's having weather in her area, it says.
Okay. Well, if you do have more questions or if you want to comment, Shannon, please feel free to add it in the Q&A if you're not able to speak, and I'll make sure that Kelly can answer that. All right, Kelly, sorry for the interruption.
That's no, please do. I should probably pause a little bit too here, give you more time so you don't feel like you just have to catch me when I'm taking a breath. Okay, so let's talk about what types of orders actually are considered protection orders by this federal statute. And I'm not going to read this to you all so you can relax a little bit, but look through this and see that it's really any order. It doesn't matter what the order is called, as long as it's issued by a civil or criminal court for the purpose of preventing violent or threatening acts or harassment, sexual violence, stalking, contact or communication with, or physical proximity to another person. So there are probably other orders that are, it could be even provisions in a divorce decree that meet this definition. Although I don't know what we do about the statutes usually have an expiration date with them in the protection orders, but you can think about that. And it can be so long as the civil or criminal order was issued in response to a complaint petition filed by or on behalf of the person seeking protection. So the person, the applicant, the victim, has to have requested this order that's going to prevent these violent or threatening acts. Now, this next piece, B, is super important too. It also includes any support, child custody, visitation provisions, all of these other things that are inside of this order that's preventing these violent or threatening acts. And that's important. And let me give you an example. Here in Oklahoma, we have, where I am right now, we have state statutes that don't, at least at my last check, don't allow custody to be litigated in a protection order hearing. Now, you can ask for the child to be on the protection order, and if you have enough evidence, a preponderance that the child was in danger or in fear of imminent harm, whatever the statute requires, you can get the child put on the protection order. But as far as going in and litigating custody, visitation, child support, you can't do that in our state courts. However, the majority of our tribes here in Oklahoma do allow that. And that's an interesting maneuver on the tribe's part, because what we think we know in this field is that if, especially in a domestic violence case or a sexual assault by an intimate partner, if there are children involved, children are oftentimes the pawns that are used to gather evidence, to spy, to do different things. So the tribes put a stop to that by address that, I should say, in their own tribal legislation to allow the tribal judge to or put custody orders, support orders, those sorts of things in the protection orders. So this should make it clear that if Cherokee Nation issues a protection order to one of, to a citizen, and it contains custody and visitation and child support, when they cross outside of Cherokee Nation Indian country into the state lands, that the state would enforce that as written, including the custody provisions that a victim could not get in the state court. Does that make sense? So this whole statute is Congress trying to address that, to say, yes, all of these pieces that are included in this order that has for its purpose protection, that is a part of the protection order, and it's entitled to full faith and credit enforcement as it's written. Next slide. And for those of you who might not be lawyers, again, those citations that I just gave you, the 18 USC 2266 and 2265, you should be able to Google those. And those statutes should pop right up for you. That's the reason those are in there. So that's what is a protection order according to the federal law. Now, what has to be in the protection order to trigger this federal mandate of full faith and credit of that protection order as it's written? And here's the statute, and it basically says any protection order, and we just went over the definition of a protection order, that is consistent with subsection B, I'm going to paraphrase that, should be enforced as it is written. Okay, no questions, should be enforced. So let's go to the next slide and let's see what B requires. Here we are. This is what has to be in the protection order to trigger the federal full faith and credit mandate. It can be issued by a state, tribe, U.S. territory, and it's consistent. It triggers this full faith and credit mandate if the order demonstrates or indicates that the court, in our case, it's a tribal court because we're talking about tribal protection orders. If the tribal court has jurisdiction over the parties, that's the plaintiff or the victim and the perpetrator, and has jurisdiction over the matter. Okay, so what that means in lay terms is the tribal court had subject matter jurisdiction to issue this protection order. And looking to those tribal statutes is where you're going to find that answer. So jurisdiction over the parties, jurisdiction over the matter, which is issuing the civil protection order, and third piece, reasonable notice and opportunity to be heard is given to the person against whom the protection order is sought. And this reasonable notice and opportunity to be heard has to be sufficient so that it doesn't seem unfair. In other words, the defendant has been served with the copy of the request for the protection order, the emergency protection order is issued by the judge, the defendant's gotten a copy, and also the defendant got a copy of the notice and the day and time that the judge will allow the defendant to have a say in this case. So I think that's really important, and I think tribes do that a variety of different ways. I will tell you the federal and sort of U.S. Supreme Court case parameters that we use here comes from U.S. Supreme Court case law, and really it's things like we're looking to see if the defendant had minimum contacts with the tribal jurisdiction such that it doesn't seem unfair that that defendant's being asked to come in before the tribal court. And the things I would ask from the bench about these kinds of things is such, do you have a tribal card tag? Or this is, again, if there's a relationship. If it's a stranger, I'm going to be looking to see, has that caused the victim fear, and is the victim in Indian country? I'm going to be looking at all of those sorts of contacts with the tribe to demonstrate that it's not unfair if you're going to sexually assault a Native victim to think that victim is going to come into the tribal court to ask for relief. And I'm going to rely heavily on my tribal statutes as well. Next slide. So those three things trigger VAWA, full faith and credit, for the tribal protection order, all protection orders, really. Can I back up one slide there? I skip over this, and some of you may need to really focus in on this. It's under number 2 there, and it's the last part of that segment. In the case of ex parte orders, that means orders where only one side has had a say. The victim comes in, I'm notified there's an advocate and a victim outside my office requesting a protection order, and the victim comes in with the advocate, and she's sworn in, and she's telling me what happened, and I'm deciding, looking at my statute, is that enough? I'm only hearing from one side, and I say, yes, it's an emergency. I think she's in danger. She's in fear. I'm going to issue this order, and then the statute tells me how many days the order can be in effect before we set a hearing. So in those kinds of ex parte orders, notice an opportunity to that defendant really must be whatever that statute, tribal statute, says it needs to be. Like if it says if an emergency order is issued within 10 business days, there has to be a hearing. So we're going to try to serve the defendant. We're going to have the service card or the service affidavit put in the court file, and we'll know also, we'll have a copy of the notice and opportunity to be heard that's been given to the defendant. If we can't get the defendant, hopefully that statute says I can continue it, and we'll just keep trying, and I can continue that ex parte order. I will tell you, unless we can demonstrate some sort of knowledge, we can do that through a whole lot of different ways, but some sort of knowledge on the part of the defendant, that the defendant was aware of the terms and violated them, right? If we're thinking about a violation. These ex parte orders are on shaky ground legally. They're still necessary, but I think we really need to get service on the defendant. We'll talk more about that in a few minutes. Next slide. Those are the 3 prongs that trigger VAWA, full faith and credit. If we're talking about mutual orders, and those are the orders where the plaintiff is there, the victim, and she's wanting the protection order, and the defendant shows up and says, well, you know what, judge, I'll agree to that if she, you order one against me. Okay, so Congress put down some really specific requirements if these are cross protection orders. And Congress says those really aren't going to be entitled to full faith and credit unless there are written requests. In other words, the plaintiff files an application for protection order. The defendant also has to file in writing and file with the court a request for the protection order, or that the court makes specific findings that each party and why. I think he did this to her, I think she did this to him, and I'm going to issue cross or counter protection orders. These don't automatically get full faith and credit. So if you're dealing with a case that this is going on, you want to go back and really be sure that you're meeting one of these requirements so you can get full faith and credit of that protection order. Next slide. Now let's talk about the parts of the protection order. And are there any questions? Anybody want to ask anything at this point? Because we're gonna talk about these. And I think in a perfect world, what I would really like for you all to be able to do is to get your protection order forms and have them handy. And I'd be sitting there with you, and we'd go through each piece of this so that you can tell if your forms might need some adjustments. So what we start out with, if there aren't any questions, I don't see any in the chat, is the heading or style. You'll see that it needs to say what court. I've seen some interesting Pieces in the heading or style where clerks list the court phone number, the address of the court, the hours of the court, and those sorts of things in a part of the heading and style. Sort of just, to me, sending that message is that we are a sovereign, we are the tribal court. If you have questions about this protection order, here's who you can contact about that. So the heading and the style, and the introduction, procedural posture, that's usually going to be the first couple of paragraphs. Then here we see number 3, the language that's going to trigger VAWA, full faith and credit. The findings is that part of the order which I don't see often enough, is where the judge is listened to the testimony, read the request, the affidavit from the victim, and determines which pieces of that or all of that the judge finds credible, and actually puts that in the order. That's so helpful later on if there's additional litigation. Remedies, those commands of the court setting about the parameters of the defendant or respondent's behavior. You may see warnings to the defendant in all caps that says, if you violate this, it could be a crime. This is entitled to full faith and credit by federal law, just a whole host of things like that. And then the service language on the order, which says the defendant was served, this was read in open court, the defendant was served with a copy. Anything related to service that's going into or at the very end, usually, of the protection order. And one part that I don't have down here that I think is important, super important, is how is this tribal protection order going to be entered into a federal database? So, and sometimes it will be a state database that feeds into a federal database, so that any law enforcement officer that's working at 3 or 4 a.m. can get on and look up the protection order and see the respondent and the respondent's physical characteristics and the command of the court and how long the order is in effect and those sorts of things. So that's going to be a very important piece of getting your enforceable tribal sexual assault protection order. Next slide. All right, talked a little bit about style or heading. You're going to see the type of case there, and that's usually civil or criminal. Maybe it'll say family, maybe it'll say DV. And that, if it's going to be called a sexual assault protection order, I think that is where you're going to see it up at the top, probably going to be the title of the order. And if you're uncomfortable, if the victim's uncomfortable with that, I would trust you advocates to see if there's any way that you can just have it say protection order. Also, the docket number the clerk uses and the NCIC identifiers. That's usually found on the very first page, although it can be a separate cover page, and it's going to list any of the hair, the eye color, possibly the weight, the height of the respondent, any tattoos, markings, things like that. You will find that on the protection order. Next slide. Meanwhile, if you have questions, hopefully everybody out there is awake. The introduction piece needs to say which judge is presiding over the case, the date the hearing is being held, who is in front of the judge. This is going to be really critical if that defendant says he didn't have notice of what went on there, but the defendant is present. Also, whether either party is, it really should be member or non-member, because non-member will include all Indians of federally recognized tribes that are not members and all non-Indians. So that term probably should be a little bit different there. It will also list if either side had an attorney and list the attorney's name. It's going to go into a little bit of the history about the plaintiff or the petitioner. The victim comes in and filed an affidavit or petition with this court on this day. The statute says we need to have a hearing within this many days. It's going to lay all of that out. Again, why? Because we're thinking about enforceability outside of Indian country. That's exactly why we're doing this. And also, what I really would like to see in a perfect world is that a tribe's protection order form cite to tribal law. It's going to cite to the tribal constitution if that's applicable. It's going to talk about the protection order statutes. Those numbers are going to be in there, because what that does is tell people outside of Indian country that may not know anything about Indian country, wow, they've evidently done this according to tribal law. I mean, it looks legitimate. So that's super important. Next slide. Here are the 3 prongs, again, to kick in the federal mandate for full faith and credit. If your tribal constitution says something like, the tribal council or this constitution establishes a civil and criminal court who will hear all civil and criminal types of cases, that would need to go in this order. If there are particular tribal statutes that say the tribe may exercise civil jurisdiction over cases involving domestic violence, we want that in there as well, the citation to tribal law. And this, I don't want to get down in the weeds on this. I just want to make sure everyone's aware of it. There's a lot of gray area about a tribe's the authority of a tribe to civilly hear matters involving non-members, that includes Indians from other federally recognized tribes and non-Indians, that arise on fee land within Indian country. So I haven't lost everybody there. There's just some cases, the Montana case that says the tribe cannot exercise civil authority over non-members, over matters arising on fee land within Indian country, unless the tribe can meet one of 2 prongs, okay? So that's a little bit problematic, but Congress came back in 2013 and tried to make it clear, I think, under 18 USC 2265, that tribes do have full civil authority to issue and enforce civil protection orders over matters that arise in Indian country, and that's defined by federal law. If you're a reservation, it's anything inside the reservation boundaries. If you're a tribe without a reservation and you're doing sort of a checkerboard trust land, it's within the trust land. So, or matters otherwise within the authority of the tribe. And there's been some, that's not been decided what that means by a court. But I will tell you, to me, I think there's a good legal argument that or otherwise within the authority of the tribe means if tribal law says you can't, then we can do that if that's within your Indian, even if it's outside of the Indian country. If the tribal law allows the tribal court judge to hear it, it's a civil PO or it's about enforcing a civil PO, the tribal judge can take care of that. So next slide. Hope I didn't lose everybody. Like you're going to do tribal civil jurisdiction in 10 seconds. And it's a very complex topic. So when we talk about this subject, now we're going to get it deeper into these 3 prongs, because I would hope for every tribal court sexual assault protection order and every tribal court protection order for that matter, it's triggering this VAWA full faith and credit. And I can tell you, I've seen protection orders issued that come across my desk when I was on the bench that were 1 paragraph long. And there is no way that they triggered VAWA full faith and credit. That victim thought it did, but it will probably not be enforced outside of the tribe's territory. So we've got to really get this right. We've got to get the enforceability draft down. This is the federal statute here. Again, I just went over that with you. I put it in bold. I think Congress was really, again, this is not tested in court, but I do feel Congress was being clear, trying to correct a case that occurred in Washington that arose in a tribal court involving non-members, and the federal court said the tribe didn't have subject matter jurisdiction to issue a protection order. I think this is clearly the legislative history of this statute says that's one of the the target's focus was to correct that holding. So making it clear tribes have this full civil jurisdiction to issue and enforce civil protection orders involving any person, whether they're Indian, a member, a non-member Indian, or a non-Indian. Full civil authority to issue and enforce these civil protection orders. Again, couple of parameters here. Matters arising anywhere in the Indian country of the tribe that's issuing the order. And that can be things, you got to look at the statute, the tribal statute, but that can be things like fear. I got a text while I was at work at the casino or the, you know, this tribal business, and I'm scared. That happened in Indian country. It doesn't have to be the physical act of sexual assault happened in Indian country. If there's fear, if that's what that sexual assault protection order statute allows, the victim says that's what the judge is going to look for. Or if the matter arose or otherwise within the authority of the tribe. To me, again, not tested in law means if this sexual assault happened outside of Indian country and that victim has come into Indian country and according to tribal statutes is eligible to ask for protection order and can meet the burden of proof, I'm going to issue that protection order under that provision right there. Because we all know how dangerous these cases can get. And the tribe as a sovereign has the responsibility and a right to keep victims and citizens safe, tribal citizens safe. So there's that piece of information for you, and that triggering subject matter jurisdiction to trigger the VAWA full faith and credit. Next slide. All right, let's, here's the Montana test. If that's not what, my interpretation is incorrect of the federal law. And if in fact Montana still applies when a tribal court judge is issuing a protection order, civil protection order, in matters that involve non-members. Here are one of the two tests that the tribal court judge must meet. And I will share with you, when I was issuing, as a tribal judge, issuing tribal protection orders, I did both because I wasn't sure, since the other statute, the federal statute has not been interpreted by federal law, federal courts. I wasn't sure. And my biggest fear sitting on the bench is that I was going to issue a protection order that didn't trigger the subject matter piece of VAWA full faith and credit. So I did both. I did it both. I would ask questions and I would make my findings that if there was a consensual relationship, I talked about that. If not, I would talk about how these crimes threaten or have threatened the health and welfare of the tribe. So I would do both. Next slide. All right, now the second prong was jurisdiction over the person. And I will share with you in reality what we're thinking about in triggering this. And again, this all has to be written in the protection order. Jurisdiction over the defendant or respondent. I'm going to say defendant just so I don't have to keep saying both. I need to show those minimum contacts, or I need to show the defendant is present and not contesting subject matter jurisdiction. The defendant knew that this was a tribal member. I need to be establishing that for my civil protection order, and that can be done in a whole host of ways. I'm sure you can think of many that I haven't even mentioned yet. And let's see, I want to make sure I get service. That's huge. That goes with due process. And a lot of tribal courts will have notice of hearings or order to show cause, and you are commanded to show up at 2 o'clock on July the 12th to show cause why a protection order shouldn't be issued against you, or something like that. Something that's showing the defendant has been given notice. Now, that would be great if we could do that in every case, but in some cases, tribal statutes may allow you to do this by publication, that this hearing is going to take place. Some tribal statutes will allow you to do something like show constructive notice of the defendant, and that might be something along the lines of testimony by the victim petitioner who says he knows it's now because he texted me and he said he wasn't coming and he hadn't been served, and so the court couldn't do anything. Those sorts of pieces of evidence can come on in, and I'm gonna look to the tribal statute and see if that's enough for me to go ahead and issue an order to comply with due process. The defendant obviously knows about it if he's texting you about it. All right, next slide. We'll move on. Again, the jurisdiction over the person and jurisdiction and the due process pieces sort of have a crossover there. We're looking for, again, minimum contacts. We're looking for service. If the defendant appeared. If the defendant appears and does not contest jurisdiction, you got him. He sort of consents then because he doesn't object. I will say subject matter jurisdiction is more driven by a statute, and parties cannot consent to subject matter jurisdiction because that's set out by tribal statute. That really is the parameters of the types of cases the tribal court has been authorized to hear. Next slide. Okay, I'm gonna briefly pause, let everybody take a deep breath. I feel like we might could do some exercises, stretching, because I don't want to lose you. These pieces are super important to the enforceability of the tribal sexual assault protection order and all protection orders for that matter. So these are the findings. These are the pieces that take a little bit extra time from your tribal judge, but they're critical because they are a finding of credibility, of believability by the judge on allegations that came out during the court. And thinking down the road, some tribal statutes, and you may be navigating tribal and state courts here, I don't know, but some tribal and many states will have what's known as a presumption for custody statute. And it's something along the lines of if a judge finds credible evidence that domestic violence or violence has taken place, that there's a presumption that the perpetrator or defendant should not have custody of the child. This is again going to be that sexual assault where it's an intimate, there's that relationship, intimate partner relationship. So I'm thinking if you get the findings in the protection order, you don't have to, you can kick that presumption in for future custody battles. Also, if I make these findings in my tribal court that the defendant did on July 12th at 2 o'clock sexually abuse or commit sexual violence against the petitioner, that this isn't a criminal case, but it might have some ramifications for the federal habitual offender prosecution for these crimes that occur in Indian country. And also may provide some of the elements necessary for the tribe exercising special domestic violence criminal jurisdiction over non-Indians for tribes that are exercising that. Any questions about that? You usually have to ask the judge for the findings. The way this would happen in the tribal court is if there is a victim advocate there and no attorney with the victim advocate might stand up and say, Judge, we would ask that you find all the allegations in the affidavit are true and incorporate those into your protection order, something along those lines. Feel free to ask me anything if it about getting these findings in place. Some judges get grumpy because, you know, like I said, time is of the essence and they've got 50 cases to hear in a day and they just want to check a box, but you need these findings. They can be you decide, the victim decides, but if you feel that the victim's going to be facing some of these issues later on, you may want to get these findings in your protection order. Next slide. Again, these are allegations the judge or testimony the judge believes to be true. I already think I covered all of that. So let's go to the next slide. Sorry, I get ahead of myself. All right, those were the findings, what the judge believed happened. The remedies, again, I said these may be driven by your tribal statutes. It's the tripwire for the defendant. It is the parameters that if the defendant gets one toe out of line, the prosecutor, if these are drafted clearly and specifically, can assert a violation. It also is very helpful to outside jurisdictions for these remedies to be clear and precise so they can, outside law enforcement, can determine whether or not a violation has occurred. It must be requested by the petitioner in most cases. And let me say a word about that. If the petitioner wants a particular remedy, let's see, something like I would need, if it's a stranger sexual assault, I don't want that contact with the perpetrator, and I don't want the contact with perpetrators' families or friends. And I need him to stay away from me. And those are not detailed enough. But what it might say is that I would command the defendant to come no closer than 100 yards or to whatever you feel is appropriate to the petitioner, any place where the petitioner might be. And I would write in there, you are commanded to leave, and you cannot come any closer than what this order is saying. And furthermore, you know, that third party contact shall not take place through social media, through in-person contact, through you sending things through the mail. We're going to get really detailed with that remedy as well, so that it's very clear. If the petitioner says, well, this has been violated, we can prove that beyond a reasonable doubt. And also, law enforcement at 3 a.m., if these are worded really broadly, is probably just going to give a little warning if you get that and go on. We really need to make sure that we're writing these clearly and detailed enough to where we can get outside enforcement. Next slide. More on remedies. I've already mentioned that'll be driven by tribal statutes, and you're looking, if you have a laundry list in your tribal statute, you're really looking for that wiggle room, that statute that says any other remedy the judge feels is necessary to keep the victim safe or to stop the violence, something like that. So check those statutes. And if you're going to request a remedy, in your mind, you're thinking we need some sort of testimony or evidence to show a need for that remedy. So you don't just ask for it if there's no evidence in to demonstrate you need it. And the victim might be saying, I'm afraid when I walk to school that I'm going to see this person, that I'm going to, and so I need you to have this person. I need to know that person's not going to be near me because I'm afraid. That would be enough probably of a testimony to get the remedy of no contact and stay so many yards away, something like that. Next slide. The warnings to the defendant piece, I've mentioned a lot of those. It may also alert the defendant about firearm and ammunition possession. If the order has certain language in it, and we're not going to go over that today to kick in the federal firearm prohibitions, that may just kind of warn the defendant, although no warning is really necessary if the correct language is in the order. And I have been seeing lately a lot of orders in this warning section that will tell the defendant that the petitioner or plaintiff cannot violate the order by inviting the defendant over, basically focusing on the defendant's conduct and not the victim's conduct, because the victim's not ordered to do anything here. This is all about the defendant and the defendant's behavior. Next slide. Service language we've talked about already. The tribal statute should tell you how this needs to be served. Some will allow law enforcement in person. Some will allow process servers to go enforce. And I will just mention again, if the tribal judge gets in the habit, if the defendant's in the courtroom, of reading the remedy, the command, even if it varies slightly, I mean, just reading it and checking that this was read in open court, these remedies have been given in open court, that you've told the defendant you will serve the defendant with a paper copy, and the defendant's given you a mail address. All of that lends such credibility to the prosecutor who's trying to enforce this protection order criminally, bring criminal sanctions. Okay, next slide. So, any questions? That's just kind of summing up the protection order, sexual assault protection order, differences and similarities, triggering the VAWA piece of that, the importance of each section of the protection order. And now I'd like to take maybe the next 5 minutes, 10 minutes to talk about emerging issues on enforcement of tribal protection orders. And I wish that I were here to tell you, hey, since we have this federal mandate, and it's been in effect since 2013, everything is wonderful. Tribal courts are issuing their protection orders, and they're drafted beautifully, and all outside jurisdictions are eager to enforce the tribal protection order. And that's, to this day, hopefully in the future, that is not true. Some areas are struggling more with enforcement issues of their tribal protection orders outside of Indian country than others. So any of you listening out there, it's not enough to get a beautifully crafted tribal protection order that really just meets all the requirements in this slide deck if outside jurisdictions just totally refuse to recognize the tribe as a sovereign and to recognize and therefore will not issue tribal protection orders. And I think the number one thing I heard sitting on the bench was, you don't have jurisdiction to issue civil protection orders over non-members. You just don't have it. Or you have a non-Indian defendant, you can issue a civil protection order against that person. So there's a lot of misunderstanding and a lack of education outside of Indian country on civil authority of the tribe, the civil jurisdiction of the tribe. So how do you know? How do you know if your tribal protection orders are being enforced or not? And I put just a very short list here for you. You can check with your tribal coalitions. They're the go-to for tribal victim advocate organizations. They do a lot of training and technical assistance for tribal victim advocate organizations. If you go to tribaltrafficking.org, you will find it's a TLPI webpage. It lists all of the tribal coalitions, the contact numbers, the kind of services, a lot of information, their service area, that sort of thing, if you're wondering who your tribal coalitions are. We also have there's a national tribal coalition, the Association of Tribal Coalitions to End Violence, I believe. And the executive director is Dawn Stover. And she also works over all of the tribal coalitions. It's another great place to ask about enforcement issues. You can ask your tribal victim advocates. They'll tell you, they've got their finger on the pulse about, they'll even probably tell you counties. This county within this state will enforce and these counties will not. And they get a lot of their information from going into court with these victims. And the victims are telling them also if they're having trouble getting their tribal protection orders enforced. Data, you can meet with state prosecutors in your area. There are tribal state collaboration organizations. You can ask there. And you can talk to state law enforcement officials to say, will you enforce these tribal protection orders? So first, you've got to get your finger on the pulse about, are we even facing an enforcement issue outside of Indian country? The next slide. I wanted to put together just a few examples of collaboration efforts. Again, wishing I could tell you, hey, look at these. These are all working beautifully. They look nice. I like what they say. The struggle is real. And as an elder mentioned to me the other day, it's a step in the right direction. So let's go to the next slide. And we're going to briefly run through a few of these, just some interesting movements. Washington State has issued an Attorney General opinion about the enforcement of tribal protection orders. And that's an interesting way to go at this, because if you have to do a little research on your own here, Googling your state, your Attorney General, and who can ask for an Attorney General opinion. But typically, the state attorney general is over all the prosecutors and in some cases over all law enforcement within the state. And a command from the attorney general goes a long way towards policy of enforcing tribal protection orders. So again, you'll have to research who, not everybody is has the standing to ask for an attorney general opinion. So you'll have to see who is eligible. Next slide. The we in Alaska also have an attorney general opinion. Here's the question that was asked, and I think it might have been asked by a government organization or a government official for Alaska to render an attorney general opinion. And Alaska's, the attorney general commanded and declared that VAWA preempts any state registration laws. So you don't have to register your tribal protection order before it's enforceable in Alaska. And that Alaska must enforce unregistered tribal and foreign protection orders as though they were issued by an Alaska court. And I believe there was also a requirement that the protection order had to have the triggering language for VAWA, full faith and credit to be enforced. Next slide. California, a little bit different here, issued a California Department of Justice information bulletin going out to law enforcement and prosecutors. And again, if you Google, these will come up. And it declares that presentation of a protection order that identifies a protected party and the purpose against whom parties against who this enforcement is sought and on its face appears to be currently in effect. That is probable cause to believe it is a valid tribal protection order, and it has to be enforced as if California had issued the order. And it even goes further to say if the victim is sort of saying, I have a protection order, but I don't have it with me, that the enforcement, usually law enforcement, can ways for that law enforcement to find probable cause that a tribal protection order exists. And that's why it's super important to get these expiration dates in your protection orders as well. Next slide. California you can see what the struggle was here. California in this Department of Justice bulletin also was very clear. You cannot, law enforcement, require a certified tribal court order as a condition to enforcing the tribal protection order. You can't require the victim to go register or file that tribal protection order with the California court. And you cannot require, as a prerequisite to enforcing this tribal protection order, that be entered into the state database. And I told you that struggle is real for many tribes, even having access to a database that will filter into the federal database. There's a program now called the Tribal Access Program, or TAP. It's a grant program that results in, to the successful applicants, results in a terminal and training for tribes to enter their own protection orders into the federal database, not having to go through any states. So here are a couple of links if you're interested in reading that. I just wanted to kind of get you thinking about enforcement of tribal protection orders, and if you are struggling with that issue, to give you some ideas about how others are addressing that. Next slide. Again, Washington State, here's the question, and it's a resounding yes. You have to enforce these tribal protection orders. And again, I believe it's talking about you're going to have to meet trigger. The tribal protection order needs that language to trigger VAWA full faith and credit. Next slide. More here. And it's saying, because a lot of states say, tribes, you're going to have to come on in and let us load your protection order in our state database. Some states will even change the heading from a tribal protection order to a state protection order to enter it. That is totally goes against the federal law that we've been talking about, VAWA full faith and credit. So they were having those struggles in Washington, and here's their attorney general giving this command that it will preempt state law. Next slide. Oregon, this is a recent 2020 memo, sort of an agreement between Oregon's attorney general and Oregon's U.S. attorney that is there in Oregon. And it is an agreement that Oregon law requires tribal protection orders to be enforced. There's no requirement because Oregon, previous to this issuance, was requiring tribal protection orders to be registered in the state registry there in Oregon. So this addressed that and touched on the mandatory arrest law. So this is a step in the right direction there in Oregon. Next slide. Again, saying the same things, that they're going to need to be, tribal protection orders if they're valid, they appear valid on their face, they need to be enforced as they are written. Next slide. Okay, so this is sort of the end of the slideshow. I would ask if you have any questions again to bring those up. Be sure to seek out information on enforcement issues if you're not familiar with enforcement issues, to see what kinds of barriers you're facing on getting these tribal protection orders enforced outside of Indian country. It's a matter of victim safety. It's a matter of tribal sovereignty as well. Right? With that, I'm going to turn it back over to Jill to see if we have questions or comments.
Yeah, if anyone in attendance has any questions for Kelly while we still have her here today, please feel free to raise your hand and I will gladly unmute you and she can hear your lovely voice and answer your question that way. And also the Q&A is still an available option for the time being if anybody has any questions. I do have to say, as a newcomer to this area, what I did hear over and over again from you today, Kelly, is clearly that the language needs to be very specific and clear so that prosecution can actually happen. That's like the one thing I keep hearing over and over again. Make it very clear so that the judge and the prosecutor have a lot more to stand on.
That's well said. Yes, that's great. And the fact that we need tribal judges to sort of revisit their, possibly some of them are doing a great job, but they may need to go back and revisit their forms and the way those forms are drafted. Yes.
Right. All right. Well, I have a big thank you in the Q&A, so that's good. Just a lot of wonderful information. It seems so complicated, but yet so simple at the same time, you know, like tribal statutes, clear and define and get it out there, and we should be able to enforce it ideally, right?
Yes. Yes.
In a perfect world.
Yes.
Yeah, yes. There it is. Yeah, exactly. Okay. Let's see. I think I have one question here that's coming in. Double check. Let's see. I'm not seeing it. The question is it possible to get a copy of the slides? And yes, the answer to that is, as soon as the recording is optimized, we will send out the recording as well as the PowerPoint to all the people that participated and attended today. So yep, that will be sent out in the next few days. And that is a common question we do get. Okay, well, I think
we have another couple of questions here.
Okay.
Savannah wants to know if we provide concrete text messages, would we still have to have very clear language? There is in fact abuse. How's the best way to protect our client without having to argue, for instance, the power and control wheel?
So thank you for that question, Savannah. I'm gonna try to answer that like this. The tribal statutes, I'm assuming that we're doing a sexual assault by an intimate partner here, possibly, because that's when the power and control wheel, the domestic violence piece, is going to come out. It's not necessarily the power and control. It could be relevant, but I know it's relevant in the DV world. So if it is a DV protection order, you will, in my mind, need to demonstrate. You don't have to go through the whole dynamic in your affidavit, but you need to go through enough to convince the judge that whatever that tribal statute requires you to prove, you've got some things to prove it. Text messages, I think, are great pieces of evidence. You know, there might be questions about whether it's authentic, whether it came from the defendant and things like that, but they definitely, with today's social media, I've had people take screenshots of Facebook and things like that, comments on Facebook. And remember, this is civil, this isn't criminal, and criminal would be facing a lot more burdens in getting those pieces of evidence in, but this is civil. They're usually going to come in. If you are in a jurisdiction where the tribal statute, Savannah, requires you to demonstrate sexual abuse, there should be an explanation, a definition of what that is, and you will need to put enough in the application to sort of tell the judge you've got enough to demonstrate this by a preponderance. It's that one drop, 51%. And that's why I asked the question at the beginning of the PowerPoint. You know, if you had a choice between going for a sexual assault protection order, where that term is going to be on the order itself, or going into, you know, a different type of order, what would you have to bring up? What would you need to bring up? And if it's a sexual assault or sexual violence or sexual abuse, you're going to have to, at least in that affidavit, and then again, even deeper into the testimony, if the defendant appears at the hearing for the final order, you're going to have to go into more detail on that, unfortunately, and that can be traumatic. And what was the next question?
It's a comment. The next one is from Candace, and she says that this was very informative and she appreciates the regular language that it was couched in, and she thanks you for it. We do have another, yes, and this is tricky, another question from Deborah. How would one respectfully allow the judge to know that he does have jurisdiction and authority to rule on sexual assault protection orders?
Yes. It's thin ice, isn't it? I totally understand it. So you want the respect of the judge, and you get some judges in there, sadly, that don't keep up to date on what the tribal statutes say, or they may be working with a variety of different tribes, a number of tribes. And so I always, this will be just Kelly Stoner advice to you. I would say, respectfully, Your Honor, I would, under such and such and such of the tribal statute, would request today you to issue a sexual assault protection order. I mean, you've really got a statute that shows the judge, demonstrates to the judge that you're asking for something that the statute allows you to ask for. Again, if you're going the sexual assault protection order route, you may, depending on tribal law, you're going to have to put on the evidence of the sexual violence that has occurred. Again, telling you in some jurisdictions, state jurisdictions, if it's an intimate partner sexual abuse, they're going to require you to do the domestic violence protection order piece. I don't know where tribes stand on that. I just wanted to let you know that. So hope that answered that. Just saying it respectfully. And also, I appreciated it when advocates bring copies of statutes with them to hand to me at the bench. Say, you're going to have a copy here if you need a copy, because the internet wasn't great there either. So I always had trouble pulling things up and get them right where I need them. So I appreciated that from advocates as well.
So you never know, you could have an open-minded and kind judge on the other side of the bench like Kelly to receive that there. Thank you for sticking around for a couple extra minutes, Kelly, to answer those questions. What a great session. It's been very informative, but I will end it at that because we are over a little bit in respect of time, everybody's. Thank you all so much for attending today. It was great to have you back, Kelly.
Thank you.
Yeah,
My
you guys have
pleasure.
a wonderful rest of your day.